First, I want to say good morning and welcome to the second annual multi-agency dealer education session. Thank you all for being here today. I appreciate you taking the time. There's a lot of good information that's going to be given today. I also want to thank you for being flexible and attending virtually. Any issues that may arise will be attended to immediately. I have plenty of other examiners who are on the line to assist me with any issues that we may have. Please keep your microphone muted unless you need something. Questions will be answered in the breakouts. If you happen to have a question, or if a question is asked by the presenter, you can then unmute and speak. Those that are coming in, please make sure that you mute your line. You will not need your camera. You can turn that off. And for any questions that you have that you want answered during the breakout sessions, you may go ahead and type them in the message area, and they will be addressed either during the session and answered right there in the messages or during the break. From 10 to 11, we have myself representing the Secretary of State, Auto Dealer Division. From 11 to 12, we have Indiana Department of Revenue, Nancy Tyree. From 12 to 1, we'll go on a break for lunch. From 1 to 2, Office of Attorney General, Mark Snodgrass. From 2 to 2:30, Department of Finance. Today we have Adam Bruniger. And then from 3 to 4, we have breakouts. And the breakouts have their own line or own room. So when the time for breakout comes, if you want to stay here, this will be where myself and the other examiners will stay for the breakout. If you want to go to join the iDoor breakout, you must close out from here, hang up from here, and then go click on their link, and the same goes for the DFI. So you have to hang up and click the other two links in order to attend their breakouts. I think that captures everything I wanted to say today, this morning anyway. Does anyone have any questions to start out before we get going? Okay, I'm going to jump right into my presentation. Oh, I'm sorry. There it is. Becky, can you see my presentation?
Yeah, but it's kind of minimized. Like I can see the whole, there. That's better.
Okay, wonderful. Thank you, Becky.
You're welcome.
Okay, so let's go on to the slide that tells us our overview. So today we're going to go over some common violations that our division sees, what to expect during an audit, notary public information, enforcement action, user roles in the dealer portal, current online functions, notes about renewals, the Secretary of State contacts, examiner areas, and contact information. So I've got quite a few things to go over. And one thing I want to remind you that questions will be asked during the breakouts. Okay. Common violations. These are the top 5 violations that we see. Number 1 being failure to deliver title within 31 days. So dealers are not getting titles to their customers within the 31 days. Improper use of interim and dealer license plates. Failure to maintain or produce records. failure to disclose rebuilt status, and unpermitted offsite sales. So let's go into some detail about the delivery of a title. All licensed dealers have 31 days to deliver title to purchaser. If you do not have the title on site when the vehicle is sold, you must fill out and give them a copy of the dealer title affidavit. And it's a form that's on our website. And when we get to the end of my presentation, we are going to go to the website so I can show you different things. So I will show you where the form is on our website. Proof of delivery. Not only must you fill it out and give a copy to the customer, but you need to keep a copy within the deal jacket also. Proof of delivery. This is another thing that we look for because we are unable to determine delivery to the purchaser if we don't have some proof of delivery. Proof of delivery could be a mail receipt or certified mail receipt. The deal jacket could be signed and dated on the front, title processor receipt, or the BMV transaction receipt. Any one of those items must be in the deal jacket once the title has been transferred to the new owner. Purchaser obligations. Obviously, they have a couple of things here that they need to make sure that they fulfill. Initial payments. So if there were any down payments, any type of payments that need to be made in the beginning, obviously those need to be taken care of. And the delivery of trade-in without undisclosed liens. So those are the two things that the purchaser is obligated to in order to receive their title. Failure to deliver title. Affidavit explains at the bottom that the consumer can send a 10-day demand letter and request that the vehicle be reversed, returned, however you want to name it. But if at the end of the 10 days that title has not been delivered to the consumer, then you must work out a deal in order to reverse the deal. The Office of Attorney General's office, they do get involved and can help with getting court-ordered titles. And there's also potential for increased penalties from our division, excuse me. Improper use of interim license plates. Interim plates can only be used at time of sale. I will say before I go on, your handouts give more information than what I have in my slides. So you are able to make notes of anything that I say outside of the slide itself. And again, your handouts include more information than what my slides do. There was no way I could include everything in the slides that you needed to know. Okay, moving on. They can only be issued at time of sale. Interim plate to be printed on purchase date, not delivery date. If the buyer waits until the 45th day of the plate date, but bought it 47 days ago, the BMV will assess late fees on the consumer. And we advise that you check the expiration date of the consumer's license plate if transferring. So those are things that can be very helpful from the very beginning. For example, if you check the date of the customer's license plate and it's going to be expiring before you think you can maybe get the paperwork all done to them, or if the plate's going to be, I don't know if there's any problem with their plate at all. My advice is to go ahead and issue a plate at the time of the sale and put it in the deal jacket. I know that costs an extra $3, but if they're transferring their plate, it might not be a bad idea to look at that as a type of insurance for $3 that your consumer will have a plate on hand if something goes wrong with the transfer. The dealer is allowed to issue only one interim plate to a purchaser. So there should only be one VIN number with one purchaser. So that purchaser could come in and buy 3 vehicles from you, 3 different VINs, and you would issue a plate for each one. But you never issue more than one plate to the one vehicle. Recording incorrect information may result in issues for the consumer. Never alter an interim plate. And when we talk about reprint versus reissue, reprinting is permissible, due to an error when issuing the initial plate. You have 72 hours to correct and reprint. Or if a plate is lost, you may go back to the original plate and reprint a new plate. Never reissue a plate in any circumstance. Reissuing a plate means it's a duplicate and must have the reason in the comment section of the interim plate. Plate must be voided with the deal jacket. So if for some reason you accidentally print 2 plates for the same VIN for the same person, that second plate you issued, you go ahead and issue that first plate to the consumer, but that second one you need to make sure that you write void on the plate. You make a note in the comment section of the system and put that voided plate in the deal jacket. This closes the loop on all interim plates issued so that if an examiner is looking at your plates, the 2 were issued, they can account and you can account for the 2 plates that were issued. Improper use of dealer license plates. Dealer plates are for inventory only. Any other vehicle must be registered with the BMV. They're only used by prospective buyer or service customer limited to 10 days. Cannot be used on a vehicle that has been sold and cannot be used on shuttle vans, parts vehicles, etc. Those vehicles are the vehicles that we expect to be BMV. So if you have someone that's test driving, obviously you'd put it on the vehicle while they test drove. Once they purchase the vehicle, you cannot use the dealer plate on that vehicle. Failure to disclose rebuilt. I don't know how many on here do sell rebuilt vehicles, but you must disclose in writing if you know or should reasonably know the vehicle is rebuilt. The dealer may use the ADSD, which is our division's disclosure form, available to download from our website. And again, this is another form, as I said, is on our website, and I will show you at the end where that is. And the title brand is irrelevant. So if it doesn't say rebuilt on the title, that doesn't matter. As long as the dealer knows or should reasonably know that it's rebuilt, they have an obligation to disclose. Unpermitted off-site sales. You would need a permit to sell or offer to sell a vehicle at a location away from your established place of business. So that would be, for example, a tent sale. You have a vehicle for sale at a mall. If it has any writing on it as like the manufacturer sticker or for sale in the window, anything, as long as the vehicle is in your business name and is sitting somewhere away from your business, that is an off-site sale and would need to be registered with us, and you would have to have that. Permit requirements include only 3 issued per calendar year, and this is commonly a complaint that we hear from other dealers. So other dealers are putting us onto other dealers that are selling vehicles away from their location. So if you would put one or two of your vehicles, say down at the local gas station or a business there in town that's right on a main route, you would need a permit to do that. Actually, a permit, but we frown on any business putting like one vehicle out in a mall parking lot. That's just not the rules of being a dealer. Your vehicle should be on your lot unless you have a specific reason to have it somewhere else. Failure to maintain or produce your records. Your records are very vital to you and to our division. Dealers are subject to an audit at any time during normal business hours. Our hours are Monday through Friday, approximately 8 to 5. So you're not going to see us on your Saturdays, any other time during the week other than that. That's generally when we would visit. Records must be made available to the division upon request. Now, most examiners will let you know in advance that they are coming to do an audit. Generally, they will give you a list or a date range of the deal jackets that they want to review, and you must have those records available when they come there to do an audit. You might also want to make sure that you've got a location that they can sit and do their job while they're there. So they would need a place to sit down, a desk to work, along with the deal jackets that we had requested. A deal jacket must contain a minimum of the bill of sale, the ST-108, a copy of the re-signed title, copy front and back, 31-day affidavit if title was not provided at the time of sale to the consumer, and the Federal Buyer's Guide as is. That's the minimum. Obviously, there are other pieces of paperwork that would be in there, say financing, the rebuilt status form, that would need to be in there. If you have a consignment vehicle on your lot, you need to create a deal jacket for it and have information regarding that consignment vehicle. And we do have a consignment form within our forms that should be used, showing that it's not your vehicle, you're just putting it on your lot to sell for someone else. Okay, what to expect during an audit? We will come in and review specific deal jackets or deal jackets from a specified time frame with all required supporting documents, as we had said earlier. We will review the interim plate log, so to verify that there are no duplicate plates. Documents related to your business, we may look at those. For example, your insurance, your bonds, your license, anything like that. We have the right to look at all of those documents. And we could ask to see proof of ownership for the vehicles in inventory. So any vehicle on your lot for sale, we may ask to see the assigned title, the manufacturer's certificate of origin, auction slip, consignment agreement, anything that shows that that vehicle should be on your lot for sale. Notary public information, just a couple of quick notes here. A notary public is an officer of the state authorized by law to certify documents, take affidavits, and administer oaths, and has statewide jurisdiction. Before notarization, this is the note that I want to make sure that everybody understands. The notary should require the personal appearance of the signer. A signer can be identified in one of three ways: identification documents, current and valid government or university document, personal knowledge, credible witness. So, in other words, if someone brings a piece of paper, one of like the power of attorney, they need to sign it in front of the notary, and the notary notarizes it then. They cannot bring a piece of paper in, signed, and then ask for that piece of paper to be notarized. That's not a valid notary. Enforcement action. Authority extends to licensed or unlicensed dealers. Unlicensed may sell up to 12 vehicles in a 12-month period. We look to the dealers to be our eyes and ears for unlicensed off-site sellers. So it's those sellers that are not licensed and they're selling more than 12 vehicles in a month period, 12-month period, say out of their maintenance garage, their own personal yard, anywhere that they're selling and you know they're unlicensed, it behooves you to let us know. And you can do that through an anonymous or unanonymous complaint, which we have on our website. So you can go out and fill out one of those complaint forms, whether it's anonymous or not, and let us know of dealers that are doing this. The dealer search function with dealer orders and consent agreements are posted on our website, and I will show you where that is also. Here are examples of enforcement: license suspension or revocation. Generally, a suspension will happen sometimes automatically, because if you have not submitted your insurance or bond by the specified date, the system will automatically suspend your dealer license. Once you are suspended, you cannot print an interim plate, you cannot go to the auction and purchase vehicles. So it kind of puts you dead in the water and unable to sell vehicles. So my advice to you is, prior to your expiration date on your insurance and bond, make sure you send that in to us. Don't assume that your insurance company is doing that for you. You get notices telling you that your insurance or bond is due, and that is on your first page of your system at the dashboard. If you're getting notices, send in copies of your bond and insurance to our office. Permanently bar owners up to $10,000 per violation. Okay, so fines for title delivery violations are set by statute: $100 for the first one, $250 for the second, and $500 for any one after that, each one after that, and that's all within a calendar year. So if you have 10 violations, it's going to be $350 for the first 2, and then $500 for the following 8, $500 each for the other 8. We have done cease and desist orders, and we have done criminal or civil action cases. Okay, so let's change gears here for a little bit and talk about the dealer portal. That's where you go in and do everything that you do as far as working with our division. So, for example, your interim plates. If you need additional dealer plates, anything like that, you're going to go to the dealer portal to handle all of that. And we're going to talk about the user rules for each one of those people that have access to the dealer portal. The top #1 role for the dealer portal is the primary user. The primary user should be the person that is overall responsible for the operation of the business and one that is not likely to change. So generally that's the owner. If you make the general manager or your admin the primary user, if they quit tomorrow, it's a lot harder to change someone in the system from primary user to another as another primary user. So if you have me set as a primary user and I quit and now you have to assign someone else, it's a big deal to have to make that change. So that is why we recommend making the owner the primary user. If you're the primary user, so if you assign the owner as the primary user, that's the only role that that person should have. You should never assign another role to a primary user. We strongly recommend the primary user on an account be the owner, officer, or partner, and that primary user logins are not shared for the following reasons. So if that primary user shares his or her logon to someone else, you have run the risk of some potential problems. Office managers, sales managers come and go much more frequently than a change in ownership occurs. So there will be less maintenance involved if the primary user is an owner who can then remove and assign administrators on the account with changes in staffing. Okay? Should a current or past employee abuse the ability to print plates from the portal, there would be no way to pinpoint who was printing the plates and no way to stop them until we assist with changing the primary user if the primary user account is being shared by many. So in all of this, what we're saying is each person that has access to your portal should have their own login. And some companies use their dealer name as the part of the login. So it's Rhonda Miller at abcdealersales.com. And then it may be Sue Smith at abcdealers.com. So each one has their own login, and you can track to see who's doing what within your system. Pardon me, I'm going to take a drink. Thank you. Assigning the primary user more than one role can cause issues that may result in system telling the primary user that their access to interim plates is denied. So if you do have a primary user with another role, this is what's going to happen. You're going to be denied, you're going to be locked out, there's going to be a problem. So again, the primary user is the only role that that person should have. Now, there are other roles within the portal. The second main role within the dealer portal is the administrator. This role has all the functions of the primary user. The only exception is that the administrator cannot edit the primary user's roles. More than one person can be assigned the administrator role if the primary user chooses. So as the primary, as the owner, or whoever it is, they are assigning who the administrator or administrators are. My advice is to have more than one administrator if you foresee people, going on vacation, being out of town. Administrators can back each other up so that things can still run seamlessly. I'm sorry, my throat keeps getting dry. So choosing your administrators for the dealer portal is very important, as they are your backup to the primary user. Okay. There are other roles, and we listed them in the beginning, but I'm not going to go through each one individually because it's pretty well spelled out here as to the functions that they have. And you can use these roles to assign to different people based on what their job is and what it is you want them to be able to do within the portal. Again, we do advise that each person that has access to the portal have their own access account. So these are the other roles that are within the portal and their functions. General user information for the portal. The primary user can be changed using the amendment owner, officer, or partner application. So once we receive that form that something's happening in your organization, you need to tell us who the new primary user will be. Users authorized by the primary owner administrator can be set to receive subscriptions. Now, subscriptions are notices that come in and There are things like there's something going on to the system over the weekend, we're going to make changes, insurance expiration notices, anything like that that has anything to do with your business. So I'm assuming you would not want everyone in your organization to have access to subscriptions. They would not have any need to see this information. Subscriptions are set on the Manage Users page by selecting the Subscriptions Management tab. And that's how you determine who sees this information. Again, I can't say it enough. Primary user is the only role that cannot be assigned to multiple people. And for control purposes, it is suggested that every user have their own individual logon. Current online functions through the dealer portal. You can do a license renewal, application license, report a dealer license plate as lost, stolen, or mutilated, request replacement of a lost, stolen, or mutilated dealer license plate, request additional plates within your current plate limit, request an increase in plate limit, both dealer license plates and interim plates, paper plates, pay an invoice, and refer to this website for any online transaction help guides. Pretty straightforward there. Your renewals. You can submit your renewals early, up to 90 days early. By doing so, you're getting ahead of all those people who wait till the very last minute, okay? So stay on top of your renewals. Check status of renewal on your dealer portal dashboard. So again, that's more information on the dashboard that you can see as reminders. So not only just your insurance and bonds and anything like that, it also will tell you the status of your renewal. Plate renewal happens after the renewal. Pay for plates online. Must be responsible to submit current copies of a bond and insurance to our office. Again, don't assume that your insurance company is doing that for you. It doesn't matter if we receive 2 copies. This way you know for sure that we have received that information. The certificate holder is the Secretary of State. We cannot accept a copy of declaration or whole policy. It has to be certificate of liability. Contacting our office at the end of the month takes a little longer due to the fact that everybody's trying to renew at the end of by the end of the month. For how-to information, you can call this number or go online for help as far as with this system. These are the main Secretary of State Auto Dealers Division contact information. So our main line is this number that will take you straight to the dealer main line. The email address is dealers@sos.in.gov, and our website is in.gov/sos/dealer. And on our last page here, these are the list of examiners that we have and the areas that they cover. At the top there, you'll see a website. That website, and I will show you in just a moment, is a map of the state and the counties that each examiner covers. So without further ado, I will close out of here and take you to the website. Okay, I am presenting the website right now. Is everyone able to see that? Becky, I'll rely on you to tell me. Can you see the website? I'm assuming if you can see the Secretary of State website, it says title delivery. Can someone tell me yes, you can see it?
You can see it.
Yes.
Perfect.
Yes.
Perfect. Thank you very much. Okay, so on our website, there is a load of information. Please, please, please check here before calling, okay? because anything you have to ask us, it's been asked before and we've addressed it here on our website. We were talking earlier about dealers. If you go to administrative actions, this is where you can search for a dealer and see if there's been any action taken against them. We keep a rolling 90 days of those administrative actions. Looking on down, by the way, this is what it looks like when you're on a computer, what our website looks like. If you were to log into our website from a phone, it would look much different. This side panel would be down the middle. It would not look the way it does right now. But you are still able to get to all the information that's on here from your phone. So if you look at license applications, for example, and you have dealer new or used, and you're wanting to apply for a new or used dealership license, here at this page, it gives you everything. I mean, everything you would need to know about applying for a license. Let's say you're already a used dealer, but now you also have boats on your lot. Maybe you need a watercraft license or something else, or you just want a new license altogether. This is where you would go to find out the information. We also have a video listing out and showing the dealer requirements. So this area of what is required when applying for a license is very important. Please check out these places on our website prior to giving us a call. If you still cannot find the information you need, then you may want to give us a call and we can direct you in the right place. We talk about renewals, license changes. The forms that we were talking about are right here. These are the different forms that we keep for dealers to use. So for example, if you needed to change the owner or officer or partner, this is that form we talked about. And there are other things if you need to make changes to your dealer license. Here is the offsite permit form that we talked about. All of your plate forms are here. Obviously, some of those things can be done now on the website or on the portal, but we still have the forms available. So, for example, if you do need to get request watercraft dealer plates, you can. Any of those things can be still done through the forms at this time. We talked about other forms, the dealer affidavit form, the consignment agreement, the rebuilt disclosure. Those forms are all right here. We've also included some B&B information in forms at the bottom. If you wanted to check to see if a dealer was a valid dealer, you would do that by going to valid dealers, which once you get here, you'll see it's the portal, okay? You would just go and search for a dealer to see if they are a licensed dealer. Simple as that. We also have here on the left-hand side guidance and policy documents, audit information. Click in there. It's all the information you would need to know about an audit. What to have on hand even, lists that, examiner, what we look for, okay? So these are all helpful things that when you are told you're having an audit, you can go here and get the information you might need to see what to expect, in addition to what you're told here. We do offer a dealer digest. It comes out every 6 months. The latest one is listed here. It was the last one was done in summer. So we, like, again, we'll be coming out with one this winter. Moving on down. Oh, wait, I skipped one. Dealer training, near and dear to my heart. Here you will find quite a bit of information about the training that we offer. We do offer a monthly training event. So for anyone new coming in or just needs a refresher on what's expected, the training that I'm doing here today, we offer monthly. So as you can imagine, new dealers coming online, those monthly sessions can be very helpful. We also offer PDF booklets of information, and they're right here. This is last year's event that we did. I will be publishing this year's event here. And then we have 2 months for this year. And those will be virtual. I believe that's everything on the website, unless there's anything else you would like to see. Again, like I said, we have frequently asked questions. And oh, I do want to show you the map. And that's going to be under Contact Us. So if you do not know who your examiner is, come here, go all the way to the bottom, and you can see a color graph of our state and color-coded with the name of the examiner. So if you are in Lake County, that's going to be Sherry Van Hook, and there's her email address. If you're down in Evansville, that's this blue, that's Casey Meek. So by looking at this form or this map, you should be able to determine who your examiner is. And I really truly believe that you should know who your examiner is, and you should be in contact with them. Any questions you have, they're going to be your first line of defense because they are your examiner. They're going to know what you need to know and to help you with what you need. The only area where there might be a question is Marion County. We have it split, and that split is Meridian Street. So there's west and east, and that's shared by Aleda Lopez and Trey Jefferson. So they will be able to help you with Marion County. But everything else is pretty well laid out there, and it's pretty simple to use. So that's what I have. Again, also there's other information on the contact list here. I don't know if you might be interested in knowing who and how to get a hold of other people within our division, but that's all under contacts, our hours, our mailing address, and so on. That's all I had for my part. I'm just a tad early. Let me go ahead and let you know that coming up is the Indiana Department of Revenue with Nancy Tyree. She will be going over their information for the Department of Revenue, and she has a wonderful presentation. You have handouts for her, make notes, and ask questions, either whether, type them in the notes or hold them for the breakout session in the end. Okay, so I'm going to turn this over to Nancy a little bit early. Let's see. Nancy, I'm going to let you do this. I need to. Here you go.
All right. Can you hear me?
Yes.
Wonderful. Okay. I'm going to pull up my presentation.
Okay.
So I'll be ready to go in just a moment.
I'll leave my mic open just in case you have any questions about opening things up.
Yeah. All right. So I want to make sure I'm doing this right. Can you see my presentation right now?
No, I see your file folder.
Okay, there. Let me. I had this working the last time we did it just fine, but right now it's giving me a little trouble. Thankfully, you've given me a lot of wiggle room to make sure I get it working correctly. So thank you.
Yeah, just go ahead and click on the up arrow, and then you have to open it in the tray at the bottom.
Oh, okay. I understand what I did wrong. There we go.
That's okay. It has to already be open, your presentation.
Yes, that's what I did wrong.
Okay. Not a problem. Maybe it gives people time to go take a quick break.
Yeah. Okay.
A very quick break. Okay, I see the small version. There we go.
Got
There
the big
you are.
version now too? Wonderful.
Yes, and I will mute my mic now. Thank you.
Thank you, Rhonda. Really appreciate it. All right, everybody. Thank you so much again. As Rhonda said, my name is Nancy Tyree. I'm from the Indiana Department of Revenue. I'm the Business Outreach and Education Manager with DOOR. So what I do is I work with DOOR's team of over 700 employees in the different divisions that we have. That includes our auditors, our policy people, our legal team, our customer service team, our returns processing operation team, and a whole bunch of others. I gather information from those experts, and then I use that to create guides and presentations like the one today, because different taxpayers in the state of Indiana can have very different requirements, and auto dealers are one of those special groups. You're not like regular businesses. There are special things that you need to know about when it comes to collecting and remitting taxes to make sure that you do everything correctly. So that's why we really appreciate the Secretary of State putting this together and letting us provide you with this information. Because when you know how to collect and remit taxes, that helps us. It means we have less audits that we have to conduct. It means we don't have to worry about collections, that we know that you're empowered to do everything you need to do correctly, and that if you have questions, you can come and ask us. So towards the end of the presentation, I will give you some resources for how to ask us questions if you need them. So this information, taxes are subject to change. Every year, new policies go into effect. We'd appreciate it if you didn't share this information with others outside of this group, because these slides may not be true 6 months or a year from now. And also, sometimes your unique situation means that the basic guidance that we provide in this presentation isn't quite right, and that because you have something special and unique going on, there would be a different answer to your question than might be the case for another business. So if you have questions, if you're not sure if the basic guidance that we provide really applies to you, we encourage you to not just take this presentation as the only information we will ever offer you, but rather go to our website. There are tons of resources there. Consult a tax professional if you want some help outside of that, or come and ask us questions. We are happy to answer your questions. Today we are going to be talking about registering, filing and paying, a couple of areas of tax that are most pertinent to you: sales tax, use tax, tire fees, and motor vehicle rental excise tax. We'll also touch on billing, payment, collections, and audits, and provide those resources and contact information that I mentioned. Additionally, I wanted to let you know, if you have any questions, you're welcome to type them in the chat. I am not looking at that right now because the presentation takes up the whole screen. But when I wrap up, I will take a look at them. If I have a little time and am able to answer some of those questions, I might. But last time there were a lot of really great questions that I wasn't so sure about. So if you want to make sure those are answered, you can go ahead and type them in the chat. But then I'd also recommend coming to our door session from 3 to 4. You can pop in anytime you want during those hours. And if it starts a little earlier, you can even do that. We'll let you know. And I will have on hand someone from our policy team and someone from our audit team who work a lot with dealers. So they are well equipped to answer your questions. All right, so let's get started on how to get set up. As I think most of you know, before you can conduct any kind of taxable sale, you need to register with DOOR and have an RRMC, a Registered Retail Merchant Certificate. That is what allows you to collect and remit sales tax in Indiana. You do that by going to inbiz.in.gov. That is the Secretary of State collaborated with the Department of Revenue, the Department of Workforce Development, and a couple of other agencies, so that when you're setting up a business, you can register with multiple agencies at once. So it's really convenient. While you're registering with DOOR on InBiz, you're going to need to set up your sales tax account, as well as anything else that you'll need to set up, maybe withholding if you have employees, for example. And then sales tax is just $25 registration fee, and we're going to get in touch with you really quickly on the status of your application after you submit that. It is important to know that that RRMC is automatically renewed every 2 years, provided that you are up to date with filing and paying your taxes. So if every period you're filing and paying on time, you don't need to worry about that RRMC expiring. If you miss a period and you don't file or don't pay, then your sales tax account it will expire, and you can get in trouble for making retail transactions at that period. The nice thing is that if you want to get back into business, all you have to do is catch up on taxes owed, set up a payment plan if you need to, and once you are in good status again, you can reapply for your RRMC. You just pay that $25 fee again, and you can get reinstated. So we try to make it easy for you to remain compliant. All businesses in Indiana file and pay sales and withholding taxes electronically. That's a requirement. The easiest way to do that is through our online platform called InTime. Business tax types can use InTime to file, pay, and do a host of other things on your sales taxes, your withholding, and a lot of other tax types. If you don't want to use our platform, you don't have to. You can also use a third-party vendor such as ADP or QuickBooks, or you can use a tax professional who will file and pay electronically on your behalf. If you're thinking that InTime sounds vaguely familiar, but you thought that you filed and paid through something else called InTax, that's because you used to, or you might still currently be doing that. We very recently made the switch from our former DOOR authorized business payment portal, InTax, to InTime. So I'll give you just a little bit of information about that so you know what's going on. Basically, we are modernizing our entire tax processing system. And because this is such a huge endeavor, we're doing it over the course of 4 years. So last September, corporate tax types. So if you were a partnership or a nonprofit or an S corporation or something like that, you started using InTime. this September, September 8th of this year, so just a month or so ago, our sales and withholding and other business tax types moved to in time. And then next year, around September, individual tax types will move there. And finally, in 2022, every other tax type is going to move to in time. So in time is a really good resource. It's customer friendly, it's convenient, and it's one system that allows reporting, remittance, and communication with us. So as I said before, use tax, motor vehicle rental excise tax, sales tax, tire fees, and withholding, along with a couple of other things that are on this slide, but the ones in red that I just mentioned are the ones that are most likely to apply to you. These are all to be done now in time. So if you've been using in-tax and you haven't made the transfer yet, that's fine. You still have a little bit of wiggle room. Many of you probably already have because you're very conscientious and we appreciate that. If you have not, we want you to know you can still file and pay for current periods on in-tax until the end of the year, December 31st. But we would highly recommend you make that transition before then, because after that, we will turn off in-tax completely. And it might be a little hard to transfer your accounts. You might have to start again new, basically, on in time, or contact us and we'll try to help you as best we can. But please avoid that if possible by the deadline of December 31st to make that transfer. All right, so enough about registration. Let's get into the meat of it. We're going to cover some of the highlights, common concerns, and guidance on new issues that might affect you in the world of sales tax. So, first of all, I think you all know this. If you are an Indiana dealer selling a vehicle or trailer, you need to collect Indiana sales tax and provide the purchaser a completed form ST-108. You will keep a copy of that form for your records, and you will provide a copy of that form to the person you're selling to so that they have it when they go to the BMV. The only exception occurs if the purchaser claims an exemption, and in that case, form ST-108E is used instead, and that discloses the reason for the exemption. That form must be signed by the purchaser. The dealer would retain a copy of it to document the exempt sale. We're going to talk about that just a little more on the next slide. The second bullet point here provides a point of confusion that sometimes we encounter with dealers. So I think you know that when you're selling to someone out of state and they are going to title or register that vehicle in Ohio or Kentucky or California, that special rates can come into the picture. We'll talk about those more in greater detail in the next couple of slides. But what a lot of people get confused about is because you're collecting at a different rate, where does the tax go? Does it go to that other state? And the answer is no, it does not. If you're an Indiana dealer and they are buying from you, it doesn't matter what state they are going to be licensing that vehicle in. You are going to be collecting the tax at the non-resident state rate when the vehicle is being titled out of state. And you will submit that tax to Indiana through the Department of Revenue, not to the other state. And again, we'll cover this a little more in detail in the next couple of slides. Okay, so exemptions. The way sales tax laws are written in Indiana, everything is taxable unless you can document an exempt purpose. If you do that, you're going to do so on the ST-108E form. That form, the back of it lists basically every possible exemption you could have. So if you ever want to read more about what kinds of exemptions might be in play, you could just check out that form. Here's some common examples for vehicles. If a vehicle is going to be used directly in public transportation, if it's going to be purchased by a government entity like a sheriff's department and used for the sheriff's department, or if it's going to be purchased by a nonprofit and used for the purpose of that nonprofit. In all of those cases, the customer would give you Form ST-108E, and they would cite the reason for their exemption. And again, you would retain a copy of that so you could prove that this was a sale you made exempt from sales tax, and they would keep a copy of it as well for their records. So the ST-108E is the main form you'll use for exemptions, but there is another form you should be aware of. Form ST-105D should be used to document dealer-to-dealer sales that are exempt because you or another dealer is buying the car from a dealer for the purpose of resale. So they're buying it for their inventory. Inventory sales are another common type of exemption. And the idea behind that is that if you are purchasing a car to be sold in your lot, you're not the final customer of that vehicle. You're going to sell it to someone else. So it wouldn't make sense for you to pay sales tax and for them to pay sales tax, that final customer. So if you are going to be using this ST-105D, that means you can purchase the vehicle exempt, and you are going to be doing it as a dealer-to-dealer sale because you are going to be reselling it in your own lot. Important to note, you can only issue a 105D to purchase a vehicle exempt if it's allowed to be in your inventory and resold from your franchise. So if you were licensed to sell Chevys, you could not use this form to purchase an exempt BMW, for example. I think that makes sense. And as I said before, if a car is going to be moved or titled to another state within 30 days, we're going to look at the sales tax rate of that destination state. You are still going to be collecting Indiana tax, and you're going to be remitting it to the Indiana Department of Revenue. But instead of collecting it at Indiana's sales tax rate of 7%, you may collect it at the other state's rate. The nice thing is that if you are doing this, if the vehicle is going out of state, you only have to collect up to 7%. So if the destination state is a state with a 6% rate, then that's great. You're collecting and remitting 6% Indiana sales tax to Indiana. But if the destination rate is, say, 8%, you can ignore that extra 1% and you'll only collect 7%. So the reason this is nice is because it allows Indiana dealers to be competitive, especially those of you who might be located on the border. Most of our border states have lower sales tax rates than us. So if you're looking at, say, Michigan, which I believe has a 6% sales tax rate, and you're on that border and you're selling to a Michigan customer, if you had to collect at 7%, then that might disincentivize a customer from going to you, and instead they'd go across the border to the Michigan dealership. So the nice thing is, by being able to collect at 6%, it makes you more competitive. Also important to note, the rate charged only includes state sales tax rate. Doesn't include local or other jurisdictional rates. So I believe, for example, in Ohio, they have a state sales tax rate, and then they also have additional county sales tax rates that are added to that base state rate. So when you're collecting this, you don't need to worry about what county in Ohio that person is going to. You're not collecting their county's rate, just the state sales tax rate. If a customer is going to their BMV and they have to file additional fees, it's usually going to be a county fee or a property tax fee or a wheel tax fee or something like that. So just be aware of that. All state tax collected at whatever rate should be remitted to DOOR on Form ST-103 CAR. This is available on InTime. Dealers and customers should also complete Form ST-108NR if they're doing an out-of-state sale and retain a copy of that for their records. You need to also provide that to the buyer as evidence that the sales tax was properly collected. All right, let's talk about warranties. So when we're talking about original manufacturer warranties, dealer warranties, or anything like that that's offered, that's not offered as an option when the product is being sold, that is considered part of the selling price. So those warranties guarantee the condition of a product and provide that maintenance or replacement parts are going to be provided at no charge or at a flat charge. And technically, because it's part of that selling price of the product, the sales tax is already on that. So what that means, any subsequent payments made by the purchaser, like deductibles or other fees, those would be subject to sales tax. But any parts transferred to the buyer under the terms of the original warranty aren't subject to sales tax. And that's because those parts or property are considered to have been sold with the product as part of the retail transaction on which sales tax was collected. So those parts are exempt, but in order to prove that they're exempt, you need to be able to tie the original warranty. So always look at the warranty, look at the language used, and make your assessment based on that. So, for example, some warranties explicitly state a replacement vehicle will be provided while warranty work is being performed. And if that's the case, then that rental transaction would be exempt from sales or use tax. However, if the warranty doesn't say that, then that rental transaction is going to be subject to sales or use tax. The furnishing of a vehicle is not considered to be part of the repair or the replacement parts in those cases. So the exemption needs to be supported by written documentation, payment from the warranty provider. Also, the fee charged for a rental vehicle provided for warranty work is not exempt from the auto rental excise tax, but it is exempt from the Marion County supplemental auto rental excise tax. So, we just like to keep you on your toes. All right. Vehicle sharing. So, as I said before, you might get a customer that gives you an ST-108E with an exemption. One of those possible exemptions is that they're buying the car for resale or rental. And that's fine. But if the customer is purchasing the vehicle specifically for a peer-to-peer vehicle sharing program, like Turo or GetAround or something like that, you should know that exemption would not be considered valid because that is not technically a rental. That is sharing. They are sharing their vehicle. And in Indiana, we very recently passed a vehicle peer-to-peer vehicle sharing tax. It's the vehicle sharing excise tax. It's a 2% tax imposed on peer-to-peer sharing of vehicles. And If this doesn't apply to you, then don't worry about it, but it's something that you might want to keep in mind. Vehicle sharing is just one of those things that we're seeing popping up more due to the gig economy. So if you encounter a customer looking for an exemption because of that, let them know they might run into issues if they try to claim that exemption. All right, leased vehicles. So I'm not sure how many of you lease vehicles in your dealership, but I'm guessing at least a decent chunk of you do. And even if you don't currently, I think it's a good idea to be aware of these rules because you never know what the future holds, right? So leases are different than normal sales, unfortunately. Basically, the lease of a motor vehicle or trailer, same as with sales, is subject to sales and use tax unless you can provide an exemption, right? But then it gets a little different. So for example, the taxability of a lease isn't based on where the customer resides. The determination is based on the vehicle or trailer's state of primary property location. That's usually spelled out in the lease agreement. So what that means is if you're looking at a situation where you are leasing a vehicle at an Indiana dealership and the customer is going to maintain or garage the vehicle elsewhere in, say, Ohio or Kansas or Florida, that is the state that gets the tax. So you will collect the sales tax up front during the deal. You will send it to the leasing agency, and they will get it to the correct state. And the leasing agency would then collect additional tax with payments after that as needed. However, if this is just a normal Indiana lease, you are leasing to a customer who's going to garage and maintain that vehicle in Indiana, then that's much easier. You're going to collect and send that sales tax to us because you are already registered to do so. So you might as well. As you can probably tell, and it just bears to state up front in case there's any confusion, when we're dealing with leases, the auto dealer acts as an agent for the lessor or the leasing company, right? You prepare and execute a lease arrangement on their behalf between the lessee, the customer, and the lessor. So that's why it can get a little bit complicated. So there are two particular situations we want to call out: if the lease has periodic payments or if the lease doesn't. So first off, if it does, then like for example, down payments, manufacturer's rebates, or periodic lease payments, those are sourced to the primary property location of the motor vehicle or trailer, as we said before. So where it's garaged or where it's maintained. And in most cases, that's the home state address of the lessee, and that is what is on the lease agreement. If we're dealing with a lease without periodic payments that don't require any kind of monthly payments at all, then the payment is kind of sourced like a retail sale. What that means is the entire amount received upon the lease is subject to Indiana sales tax, provided, of course, that the lessee is taking physical possession and control of the lease vehicle within Indiana. But the interesting thing is that is true regardless of the state of residence of the lessee or the location where the vehicle will be primarily located, registered, or licensed. So if we're dealing with leases without periodic payments, the only thing that matters is that they're taking physical possession in Indiana. It does not matter where they are going, where they are maintaining, where they are licensing that car. It's going to be an Indiana sale, basically, because they are leasing it in Indiana. All right. All the slide basically says is Again, if it's a lease without a periodic payment, you are collecting the sales tax up front and you are remitting it to us. That's the very simple version of all that legal language. And then exemptions, of course, are also important, whether this is a leased vehicle with or without periodic payments. So if the lessee is claiming an exemption and tax is not collected, you gotta, of course, use Form ST-108E. In that case, it's really important. The lessor, so the leasing company, and the lessee, the customer, need to retain a completed exemption certificate to document that. I think it's a good idea for you to keep one as well, even though you're that middle party there. All right, so that's enough about leases for the moment. Let's talk about merchandise and parts. So first of all, right off the bat, merchandise and parts are subject to sales tax unless you have a certified exemption. So hopefully this is starting to sound a little repetitive to you. That just means you understand that that is always the case. So when a customer has an exemption, his exemption certificate should be maintained, of course. And this also brings up a question that we hear from dealers every once in a while, and I wanted to elaborate on right now. So sometimes when you're dealing with those ST-108E forms, a customer will use it as a blanket exemption, which means that when they purchase the car, they're using that form. And if they come back in later for a repair or something that isn't under the warranty, they're also going to use that form again, but they're not going to give it to you a second time. They're just going to say, hey, I have that ST-108E on file with you. And that's totally fine. You can do that. Some people will say, well, how long can I keep that on file? Because it might be years between when the person purchases the car for me and when they come in for a repair. So the law says that a certificate, an exemption certificate, is good for the life of the business. However, the law also says that the information on that certificate needs to be accurate in order for it to be valid. So theoretically, you could just keep that certificate on hand, reference it when you need it, and never worry about updating it or getting a new one from the business. However, that puts you in a risky position because what if the business, for example, changed its name? So most of the time when that happens, the business should provide you with an updated exemption certificate. But, you know, humans make mistakes and businesses are owned by humans. So sometimes that doesn't happen. Therefore, it is in your best interest to check those exemption certificates every once in a while and make sure the information is still accurate. And then ask the customer to update it if not. So different auditors will have different periods that they recommend going through exemption certificates and checking them. Some will say every year, some will say every 3 years. I will leave it to you, but every couple of years, good rule of thumb to check those. All right, and then that third bullet point, sublet repairs. So what that means is an entire amount is going to be subject to tax unless it's itemized on the service invoice. If it's not itemized, it's treated like a bundled transaction. So say, for example, you're dealing with sublet charges like towing or radiator repair, right? If you're not itemizing those on the service invoice, then you have to charge sales tax on them. However, if you are itemizing them, those are services. They are not tangible personal property. Therefore, they do not need to be taxed. So the important thing to remember is if you're itemizing things on the invoice, then you would not apply sales tax to services like towing. But if you neglect to itemize things, then we're forced to treat that entire invoice as a bundled transaction, and then you have to apply sales tax to every item on it. Make sense? All right, so I think that this has become, but still have a little confusion around document fees and convenience fees. So we're going to take a minute to kind of clear that up. All right, so a document fee, when you are preparing the documents for a customer, and then you are going to give them to them and say, okay, take this to the BMV, and I've made it easy for you. I've put all the documents you need in one place, and you go take care of these. And then they will charge a fee for doing that. That is fine. However, it is taxable. That fee is subject to tax. The way that you would get around that would be by doing a convenience fee instead of a document fee. So a convenience fee correlates to the registration requirements of the BMW, or BMV, sorry. So you are not just taking all of those files and putting them together and preparing them nicely. You are also taking them to the BMV yourself and filing them yourself. If you do that, it is considered a true convenience fee, and you can charge up to 150% of the BMV fee without collecting sales tax. So it's important to just know the difference between convenience and document fees and make sure you're taxing them appropriately. Trade-in allowance, we got a question very recently about this, so I wanted to make sure we had a slide on it. So a trade-in allowance on a non-like kind exchange, for example, trading in a motorcycle for a vehicle, that is subject to sales tax. Only a trade-in allowance on a like kind exchange would be exempt from sales tax. And like kind would be a vehicle for a vehicle, or a boat for a boat, or something like that. Another rule that you need to meet if that allowance is going to be exempt from sales tax is that whatever is being traded in must be owned and titled in the name of the customer. So we do see situations sometimes where a customer will trade in a vehicle and think that that should be, that the trade-in allowance should be exempt, but it's not, because the person trading it in, they got the car from their parent, and the parent never officially transferred ownership of the vehicle to their child. They never titled, the child never got that vehicle titled in their name. It's still in their parent's name. So in that case, then that means that you could not exempt sales tax on that trade-in allowance. Another common example might be if the vehicle is in a living trust. That is not technically in the customer's name. So just be wary of that kind of thing. All right, and then RV cargo trailers. If you attended these presentations last year, you might note that we had a change on this, and there is another change on it this year, because as I said before, sometimes we just like to keep you on your toes. So the special rate for non-reciprocal states is back. And again, this is just for RVs and cargo trailers. If you are not involved in RV or cargo trailer sales, you probably don't have to worry about this. But for those of you who are, previously, you might have noticed that RV and trailer purchases by non-residents who were going to title that vehicle in a non-reciprocal state were subject to Indiana's 7% sales tax. Now, you can charge them at the rate of the state they'll title the vehicle in, provided that that's less than 7%. That also applies to foreign countries. So RV and cargo trailers, they differentiate non-reciprocal and reciprocal states. We provided a list of those non-reciprocal states on there. If you do not see a state on that list, that means it is a reciprocal state. If a customer is in a reciprocal state, you do not collect sales tax from them at all if they are licensing the RV or cargo trailer there. All right, So those are our sales tax issues. Use tax is something that most of you are going to have to deal with at some point or another, but might be a little less clear what it is. So generally speaking, use tax is the tax on any items stored, used, or consumed in Indiana. It is considered kind of a mirror to sales tax. What I mean by that is if you pay sales tax when you buy something, you do not need to worry about use tax at all. You should not be paying sales tax and use tax on the same item. However, if you purchase something and do not pay sales tax when you purchase it, then use tax may come into play. So here are some examples of when that could happen. Let's say you buy a car for inventory intending to sell it on your lot. And because you bought it for inventory, you purchased it exempt. You did not pay sales tax. When you did that, you were in a roundabout way promising to the state of Indiana that you would eventually sell that vehicle to an end customer, and that when you did, you would remit that sales tax to us. However, if you take that vehicle out of your inventory and say, you know what, I'm actually going to use this for personal use, that's fine, you're allowed to do that. However, you need to make right the fact that you broke that promise. You are never going to sell that vehicle and collect sales tax to an end customer. And therefore, you're going to need to find a way to get that tax to us that is owed. You do that in the form of use tax. So if you take something from inventory, use it for personal use, you will remit 7% use tax to the state of Indiana. That's pretty convenient. Use tax is just like sales tax, 7%. Another example could be if you buy something from someone and they should have charged you sales tax, but for some reason they didn't. We see that sometimes with catalog sales and out-of-state sales. In that case, you would pay use tax to us. And just to be clear, use tax is on the cost, not the markup. So that 7% is not the markup of what the car that would have been in your inventory, what you would have charged. It's instead on just the cost. Okay, so with that explanation out of the way, here are some common things that are subject to use tax for auto dealers. Free oil changes, the oil and the filters, because you're giving those items away free from your inventory. You need to remit use tax on that. A dealer-owned vehicle repair, that's a vehicle that's on your asset list and it's depreciated. It's your vehicle, it's not in the inventory. So you should pay use tax on that. Fuel purchased to be used in dealer-owned vehicles or demo vehicles, things like that. And then also consumable supplies. That can include masking paper and tape, oil dry, sandpaper, rags, cleaning supplies, anything that you keep and supply that doesn't go to an end customer. Other common things that can be subject to use tax, promotional items like mailers, balloons, tent rentals, things you give away like cups and t-shirts. Those are taxable, so those are also subject to use tax if you don't pay sales tax up front when you buy them. Optional warranty parts. Hey, I'm noticing a little bit of an echo. I'm wondering if there is someone who does not have themselves muted. Could everybody check that really quickly? If you are unmuted, so if you hover over your screen, you see that little microphone icon and you do not see a cross or a slash through it, please mute yourself. Okay, I think we took care of it because I don't hear the echo anymore.
And Karen, you can turn off, Karen Matthews, you can turn off your camera.
Thank you. Okay, back to it. Optional warranty parts because the customer didn't pay tax on it originally, right? We already covered that. Software licensing fees, and then data-based fees. These can also be subject to sales tax and therefore to use tax as well. Important exception to those data-based fees. So if it is a fee for something like Carfax, credit reports, electronic sales leads, or mailing lists, those are not taxable. So if you're dealing with Carfax, credit reports, mailing lists, electronic sales leads, things like that, you don't have to worry about sales or use tax on those. And the reason for why is because those are not considered tangible personal property. They're considered information. I personally find that distinction a little arbitrary, but you don't really need to understand or agree with the rule to follow it correctly. I like to say that whenever someone says that doesn't seem fair. Sometimes taxes do not make sense. We just have to make sure we know what the rules are and that we're following them, right? So if you want more information on that, I'd check out Sales Tax Information Bulletin number 2 in Bulletin number 8. And I will have a slide at the end of this presentation that has all of those. Demonstrator vehicles. These have some very special rules. So first of all, the demonstrator vehicle absolutely needs to be provided to a full-time salesperson and only a full-time salesperson in order to be exempt from use tax. If it's provided to someone else, like family members, business owners, part-time salespeople, then it's going to be subject to use tax. Additionally, we don't just keep in mind who's using it, but also for what purpose they're using it. It needs to be qualified automobile demonstration use only. So I'll outline some of those rules. If you meet these, again, it's not subject to use tax, but if you do not, then you need to remit use tax on the vehicle. So here are some of those rules. The vehicle needs to currently be in the inventory of the dealership. Needs to be available for test drives by the customer during normal business hours. The salesperson can't store personal possessions in the vehicle. It can't be used for personal trips, and it can only be driven within the dealer's sales area. And we define that as within 75 miles of the dealership. All right, let's use tax out of the way. Let's quickly talk about 2 other taxes that you might encounter. Tire fees are a 25-cent fee imposed on each new tire sold in Indiana. And that is mostly going to be cars, RVs, trailers. It can also be things like farm tractors, semi-trailers, or garden tractors with 25 horsepower or more. So think heavy duty garden tractors. It's also imposed on each new tire mounted on a vehicle at the time the vehicle is sold, including the spare tire. A new tire means that the vehicle has never been mounted on the wheel of a vehicle. And important to note, with sales and use tax, nonprofits and governments, they get an exemption if they're using that for the purpose of their nonprofit or their government work. But those entities are not exempt under any circumstances from tire fees. Okay, so they can't use an exemption form to get out of the tire fee. Here are some ways that tire fees can be exempt. If it's going to be a tire that's used on a dinky lawnmower or garden tractor, so something under 25 horsepower, then that is fine. That's exempt. New tires mounted on a non-self-propelled vehicle for personal use, like a boat or a camper trailer. or tires purchased for resale without being mounted on the motor vehicle. Additionally, we have motor vehicle rental excise tax. This is for rentals of passenger motor vehicles for less than 30 days. This is a 4% tax. And just like the tire fee, nonprofits and governments are not exempt from this tax automatically. Also, counties can add a supplemental auto rental excise tax. I believe right now the only one is the Marion County supplemental auto rental excise tax, and that is 6%. So if you're in Marion County, be aware that that's slightly different than other counties of Indiana. All right, so let's take a minute to talk about bills. So the Department of Revenue generates several bills that you could get. You can get them if you don't. That's why it's important to always file on time, even if you owe no taxes during a period. You can also get them if you don't pay on time, and so on. So if you fail to file a report or pay, if you fail to report or pay your taxes, that can get you put into our collections process. So we'd prefer if you avoided this if possible, because it can have some negative effects on you. It can impact your credit score, you can be put out for a sheriff's warrant, you can be referred to a collection agency, and also you're going to have to deal with more liability from penalties and interest. And then most importantly, as I said before, your RRMC will expire if you have unpaid tax debts. You can get back into compliance by paying those tax debts, but it's a lot easier if you never get into that situation in the first place. So, and as I said before, even if you don't owe taxes during a period, let's say, for example, your dealership does not sell any cars for a tax period. That happens sometimes. You still need to file your taxes. You just report 0. You report there is 0 sales tax owed. If you do not do that at all, we'll send you an estimated bill based on what you've remitted to us in previous tax periods. So a big takeaway here is it is important to file and pay by the due date if at all possible to avoid the collections process. Just so you know kind of what that entails, it should not be a surprise when you enter into the collections process. We send you a lot of letters. So initially, a failure to file is going to generate a letter notifying you of the delinquency. It's basically just saying, hey, might want to take care of this. If you do not file after that, you're going to get a notice of proposed assessment. That is going to be issued with an estimated amount, and you will need to pay, amend, or protest within 60 days of receiving that letter. We'll talk about the protest process on the next page. If, however, you still do not respond within those 60 days, then we are going to send a demand notice for payment. At that point, you lose the right to appeal, so you cannot protest. However, you could still pay, or we could put you on a payment plan if you need it. And then if you still haven't responded within those 20 days, we're going to put out a warrant for collection of tax. So, like I said, you are going to get several letters from us before a tax warrant is issued. There's lots of chances to make it right. And if you disagree with what the estimated bill says, you can always appeal. So like I said, if you do so within those 60 days of the notice of proposed assessment, you do so in writing, and you follow the other rules outlined in our administrative protest guide, then you can appeal any estimated amount that we believe you owe. And then if you do not want to protest, you agree with our assessment, but you just can't pay by the due date, that's okay too. We offer payment plans. They're tiered based on the amount owed. And the important thing is we just want to make sure that you get into compliance. So even if these payment plans wouldn't work for you, we would encourage you to reach out to us, explain your situation, say you need time. We'll work with you. We will. We don't want to business. We don't want to collect the maximum amount possibly owed to us. We want to make sure as you can be so that you can business. Whether you are going to be filing, paying, or making a payment plan, or making a payment through a payment plan, you are going to be doing that most likely through InTime. As I said before, that is where you will manage your corporate income taxes, sales taxes, withholding if you have employees, tire fees, motor vehicle rentals, and excise and use tax. All right, so another thing that happens sometimes is that you will receive notification that you are going to be audited, and you will be a little scared. That happens, very common. First of all, please know that just because you are being audited does not mean that you have done anything necessarily wrong. It is common, it happens, that a business can be audited and they find out that nothing is owed. In fact, sometimes we find that a return to the customer is owed. So that can happen as well. The most important thing, stay calm, provide as many certifications and resources and everything that you're keeping on file. Provide those to your auditor and talk to them, and share information with them. Make it a collaborative thing. That'll make it go quicker, smoother, and usually will be in your best interest. So if you get audited, you're going to be contacted by the auditor to schedule an appointment. Usually only takes a couple of days, though it depends on your records in general. And we're conducting audits in person and virtually right now because of COVID. After the auditor reviews all your records, they're going to sit down with you and explain their findings. If you want, you can have a power of attorney represent you during that meeting or much earlier in the audit process if you choose. That's somebody who would have your interests at heart and could represent you. And if you disagree with the audit assessment, as I said before, you have the right to protest. That appeals process that we covered in the last, just a few slides ago, that would apply here as well. All right, so we are just about ready to wrap up. Before I do that, I wanted to provide you with a couple of resources so you can do more digging onto any of these topics, because this is not a completely comprehensive presentation. This is just a quick dive into some of the most important things for you. So if you want to do more research, here are 3 great pages on our website to check out. The business tax information homepage, if you click on that, you will find a lot of links, very useful for business owners in Indiana. We also have a dealer information page. That is great because, I said before that when you're dealing with a vehicle that's being sold outside of Indiana to a customer in Ohio or Kentucky or whatever, you're going to be dealing with that state's rate. We have a list of all of those state rates and all of those special weird situations for different states on our website. We cannot guarantee that it is perfectly accurate. We try to update it 4 times a year, but you never know if another state is going to make a change in between then and when we update it. So use that as a starting point and then verify that with the destination state, but it's still a very useful resource. There's also a lot of other specific dealer information on there. And then finally, we have FAQs for a wide array of topics, including auto, RV, trailer, and watercraft FAQs. So just click on whichever one interests you and it'll direct you right to that section of the page. I also mentioned before informational bulletins. So this graphic shows you where to find them, but I think the easier way to do that is to just click on this URL here. Once you do that, you are going to be looking for these sales tax information bulletins. These are really helpful. They provide examples. They get into the weeds. They give you all of the information you could conceivably want about these topics. So if you have more questions on any of these, that is a really good starting point for future research. And then please reach out to us if you have more specific questions. Our contact us page has a lot of good phone numbers, email addresses, mailing addresses, and ways you can visit us in person if you want. We are open to in-person customer service. We'd recommend you make an appointment if you want to do so, but we have a way to do that on our contact us page. Customer feedback is also highly encouraged. You can submit it at the website that I've linked there. In fact, if you liked this presentation, you can leave feedback on there. Tell them, yeah, I like that presentation that Nancy gave. If you did not like the presentation, actually, my name is Barbara. So tell them you did not like Barbara's presentation. And then we do provide lots of ways to stay informed periodically. If you want email updates sent right to your email inbox, we have a Tax Talk blog, a monthly newsletter, and a lot of publications that you can subscribe to get updates on. So go to the homepage, scroll to the bottom, and click on the button that says subscribe to your updates. All right. So thank you so much for your time.